Hi, everyone. Harry here to talk about a race to the wire to the Supreme Court by the administration to try to keep Federal Reserve Board member Lisa Cook from participating in a two-day meeting that already has begun for the Fed, at which they are expected to discuss things today and then potentially vote on interest rate reduction tomorrow. Let me just start with that big fact. The appeals court, and I will get back to it, rejected the administration's bid to try to unseat Cook. And now the meeting has started. It's unclear to me what the Supreme Court would do about all the meeting discussion that already would have occurred if they were to approve the administration's request to bounce her now. So it's really a not 11th hour, a 13th hour effort on her part. Okay, you guys have heard the basics of the law here again and again. We are in the overall category of agency independence, which Congress has provided for in many different settings, and which the Supreme Court has approved Congress's efforts for at least the FTC in the 1935 Humphreys executor case, which now seems to be on the chopping block. But we've had a series of cases in which the court has said, yep, we know that Congress wanted to provide a measure of independence, consisting merely, by the way, of some requirement that if you want to fire the person who's either part of the board or the individual, you need some cause. You need to state a for-cause requirement. That is itself been kind of looked askance at by the U.S. Supreme Court, and it has suggested in at least many settings, not every one, and in fact, we are sort of at the last frontier, but in many settings that somehow, I shouldn't say somehow, that in their view, that violates the separation of powers by fettering the president's discretion. Now, as it is pared back and back and back on this principle with respect to different agencies, based on whether the agencies have a multiple member head or what kind of power they exercise, the court has pointedly stayed its hand in doing so with respect to the Fed. And in a sort of notorious now shadow docket opinion in the summer, it basically said, we are looking to lop off Humphrey's executor and overrule it in a case now on all fours with it involving the FTC. But the question came up there because the opponent said, well, you can't do this to the Fed, can you? And the truth of the matter is the court's painted itself into something of a corner. On the one hand, the reasoning that they've used to say, the other limitations on the president's discretion violate Article 2 sure seem to apply to the Fed and the kind of power and its structure and the like. On the other hand, everybody knows if Donald Trump can fire whoever he wants and if future presidents can put in wherever they want, it is a recipe for economic bedlam and a kind of catastrophe for world economic markets and the like. So they're looking right down the barrel of the kind of reasoning that led to the Congress, with the court approval until recently, decision to do for-cause limitations. That is, you want to put in expertise, people who are there because they know what the hell they're doing. And second, you want to put in some kind of political independence so they don't think their decisions would be subject to the caprices of a, for example, complete crazy-ass sociopath president. So there are two people on whom Trump and the administration has set their sights. This is Lisa Cook. And what is interesting about her case is Trump has moved to dismiss her, claiming, oh, I know the Congress says I need to have cause. I've got cause. What is that cause? That cause is that she filled out a couple mortgage interest applications, and they each stated, says the administration, that different homes were her primary residence. That seems not even necessarily to be true. That is, Cook has pushed back on that and said, you've got a misunderstanding here. And there was a hearing in the district court where the district court said, we are not going to kick her out for this. This is not cause. And indeed, we have, there's a cottage industry of one of Trump's henchmen going after people for this. Adam Schiff, Letitia James. There's an irony because three of Trump's senior officials have the exact same problem. There's more than an irony. There's a legal infirmity that came out of the district court level, which is this fact was part of her application to her job, to which she was appointed in 24 and supposed to go till 38. You really want longevity and tenure and job security here. And so the district court says, how can this be a cause? Come on, really, guys. You knew this already. How can you use this as your pretext now for dumping her? That was the state of play until last night, and it got to the D.C. Circuit Court of Appeals, just under the Supreme Court level. And this is getting really repetitive and I think really undermining of confidence in the courts. But once again, and it has been the case in more or less every case in recent weeks, you look at the composition of the panel, you look at who appointed the judges, you get a damn good idea what's going on. And here, indeed, you have two Democratic appointees and one Republican appointee. And by a 2-1 ruling, they say that we will not bounce her. We will not accept the administration's request that we get rid of her for cause. Why not? Okay. Without going too much into the various factual wrinkles of the different cases involving Trump's efforts to discharge employees who have a measure of protection, Cook has two different claims. One is, this is not cause. This is the thing that came up in the district court. It's not cause. You did it already. If you could say this, something that you already knew about when she applied, you could say any kind of disagreement with any policy position. And at least for now, the administration accepts the view, well, we can't do that. Wait till they get to the Supreme Court and say we can do whatever the heck we feel like because Donald Trump has an itch to scratch. But for now, they concede that much. But they're nevertheless saying that this qualifies as cause. That's one of the things Cook is saying. The other thing she is saying is, I've got certain rights here. There's a whole, there's a whole legal body of due process protections that you just can't get rid of me willy-nilly. I think here she actually found out in like a social media post, classic Trump, and about these, supposed mortgage improprieties, just boom, no notice, no opportunity to be heard, and the like. So the two members of the D.C. Court of Appeals said that in and of itself is good enough to conclude she's likely to win on appeal. Therefore, we are not going to reverse the district court. We are not going to, and this has been the game always, at this point in the proceedings, we're not going to bounce her pending the decision while we go through her claims more carefully. Now, the administration is fit to be tied. They're in this big meeting now. They want her out. And they've said they're going to go to the Supreme Court and ask for, you got it, another emergency appeal on both presumably the for cause provision and the actual, is this genuine cause, the mortgage stuff. And we know there was, so I said 2-1, and the one, Greg Katsas, a Trump appointee, well respected, and his opinion will definitely get the attention of the justices. And he's saying, first, the administration's likely to appeal. Why? Well, because under this situation, the majority is saying can't be cause because it already had happened. But he says, what about if you find out about a murder? What if you find out about terrible financial crimes, et cetera? It seems like a really make-weight argument to me. The whole point is not that it happened before. The point is they knew it before when they appointed her. So his argument about cause being potentially legit, I don't think flies. And then he's otherwise saying that the due process clause protections don't kick in, don't protect her for a series of reasons having to do with basically a fine-grained distinction about that body of law. So there you have it. Racers, start your engines. We have the administration poised to go to the Supreme Court once again, give us that emergency relief, and do it by saying we can kick her out for now while this meeting goes forward. But the meeting has already started. It is a mess to try to kick her out now. And moreover, it's only now. But now is the future in all these cases, right? And it's a good illustration of it. Just for now, while the case goes back to the district court, we'll say that we'll grant the administration's ability to bounce Lisa Cook. Think about the way it works on the ground, the practicalities, and just as is the case so often, if you and the Supreme Court, is what I mean by you, grant Trump this kind of temporary relief that could go months, you have changed the facts on the ground dramatically, probably changed the law, and left Cook, if they agree with maybe some kind of financial remedy, you violated due process. But really, once again, the shadow docket will be where this goes down. Okay, so the administration's got to get their licks in and try to once again have the Supreme Court pull their feet from the fire within the next 24 hours. They've said they're going. So keep your eyes peeled for the emergency petition once again coming. This is how we run government in Trump 2.0 with all kinds of deleterious effects. But that'll be coming down the transom. And when it does, if it's got anything of note, and I believe it probably will, we'll bring it to you. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.